It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my demystifying co-host, Brett.
Oh, I love it, Alice. Demystifying. That's what we try and do here on the Prosecutors. Is answer questions and make the mysterious a little less mysterious. That's what we go for.
And break it all down, because those of you who have been following really the mainstream media, which has just converged with true crime media in a crazy way. And I say that because usually there's like my true crime newsfeed, and then there's like the rest of the world newsfeed. And it seems like this past week they completely converged because there were massive developments. Depending who you ask. If you ask the news, massive developments in both Delphi and Murdaugh. But we're going to tell you that they're actually not that newsworthy. Little newsworthy, but the real newsworthy stuff is actually down the line. And I'm sure you guys have a lot of questions. We'd love to answer them and tell you a little bit about this next step in both of the cases, which, to be fair, they both have taken turns that are not typical in your ordinary criminal case.
They have, and I think that's why people have so many questions about what's going to happen next. We've talked about both of these cases recently and what happened in both cases. In Murdaugh, there was a motion for a new trial. Usually those are pretty standard, never get granted. This one looks like we're actually going to have an evidentiary hearing, possibly. We're going to talk a little bit about that, a little bit about what happened recently in that case. And then obviously in Delphi, if you've been following that, the removal of the defense team, what that means, what's next, and how that's going to go. We talked about this last week, Delphi in particular, and we spent a lot of time with Murder Sheet sort of on the drama of the day. I mean, that was the day it happened. There was supposed to be a hearing. The hearing was very short because the defense team withdrew, and we talked a lot about that, but people have had a lot of questions. There have been a few conspiracy theories that have popped up. So we just wanted to sort of take a step back, talk about what happened, and talk about what's next in both cases. I don't know if it makes sense to do Murdaugh first because it's a little bit less involved than Delphi. The Murdaugh development was pitched on television and in the media as a big deal, but it really wasn't. It was totally expected. So as we said, basically what's happened in Murdaugh is you have this lady who works for the court. I forget her name. Do you remember her name, Alice?
Becky Hill.
Becky Hill. There you go. Becky Hill.
Miss Becky Hill.
Miss Becky Hill, who is the clerk of the court. And she wrote a book. And at some point, the defense attorneys, they talked to a bunch of jurors, including some jurors who had been removed. And they said, hey, she talked to us during the whole time, told us that Alec Murdaugh was a liar, and basically we should find him guilty. And there's been a request to have a new trial on the basis of jury tampering by an officer of the court. Very serious charge. But the thing that was weird about it was they had already appealed on your standard grounds. Usually you have to file an appeal pretty quickly after sentencing. It can be as little as 2 weeks, 14 days. And so they had already filed that appeal. And when you file an appeal, that takes jurisdiction away from the lower court and puts it in the appeals court. Well, the appeals court, they're dealing with a record. They have this record that was developed over the course of the trial and everything else, and that's what they're going to be looking at. There are no hearings in an appeals court. There might be what's called an oral argument, which is like 15 to 30 minutes for each side. But really, you're just sort of discussing the record and maybe arguing about the law. But there's no putting on witnesses. There's no cross-examining anyone. Nothing like that happens in an appeals court. Well, all of a sudden, the defense comes up and they say, look, we have this very fact-intensive, evidence-heavy claim, and we need to have a hearing. So what they asked for was actually to stay their current appeal, return jurisdiction to the district court or the circuit court, whatever they call it in South Carolina, and allow that court to take over and to have a hearing. And last week, the appeals court, in what was not a surprise to me based on the affidavits that had been produced, said, okay, we're going to stay our appeal and send that jurisdiction back to the lower court.
And so a lot of words were just said, and we've covered this before when that filing was made. Remember that filing had affidavits from some of the former jurors on Murdaugh's trial, basically corroborating what was said in the brief. And we said that they were laying out their argument in the brief for what they would argue at the district court because they needed to show the importance of staying the case. Typically, a case will not just be stayed in order to do something else at the district court, right? Because you don't want to be ping-ponging back and forth between the courts. So you have to show, essentially, there are massive developments and they have to be explored at the evidentiary level at the district court. And that's what happened here. So even though an action happened in the Murdaugh case, nothing really happened with respect to the defense's filing. The court didn't make any rulings or explore any of the allegations made by the filing regarding Becky Hill's conduct. That hasn't been reached at all. All that's happened so far is that the defense can proceed with asking the district court to have an evidentiary hearing on their allegations. So if anyone is out there who you've been listening to saying, oh, you know, they found that Becky Hill did the witness tampering, or there's going to be a new trial. We don't know any of that yet. We've taken the first procedural step into getting there. Now, because of the very serious allegations that were in that motion and because of the affidavits that were attached to that motion, we said this back when we covered that filing. I think there is going to be a very, very good chance that there's going to be an evidentiary hearing now at the district court. And I think there should be. But that never could have happened if the appellate court kept jurisdiction. So all we've had here is that one procedural step.
And that's a really important point because this was sort of reported as if this was a win for the Murdaugh team, like a big deal. And I mean, I guess in the most basic way it was. Like the appellate court didn't say this is so frivolous, we're not even gonna do this, we're gonna keep going. But you knew that was gonna happen because they had some affidavits. And the thing about affidavits, you see them in a lot of cases. Affidavits are like the most basic thing you need to get an evidentiary hearing. You usually need some affidavits because they are sworn statements, but they're not cross-examined. They're not in front of a judge. I mean, basically, you're making a sworn statement, usually in front of like a notary public. And you file that, and basically what you're hoping is a judge will look at that and say, well, this is interesting. If this is true, that could be a big deal, but we need to have a hearing to put this person on the stand so their credibility can be judged, so you can see if that's really what they meant, so you can ask them questions. And you see a lot of people will try and rely on affidavits at various times to prove various things, and they are tricky in that way. Yes, they're sworn statements. Yes, they're evidence in that way, but you're never going to have any sort of major decision made based solely on affidavits. And so what you're seeing here is you have some affidavits which sound pretty bad for the prosecution. But since those were filed, you've actually had some other jurors who've come out and said things like, I don't remember that happening at all. So really, that's why you need an evidentiary hearing. When you have sort of affidavits that are at cross purposes or getting questioned and witnesses are confusing, you need to have people sit down in the witness stand and give their testimony and be subject to cross-examination and have to answer questions and have to explain things that maybe the affidavit doesn't fully explain. Now, one question's interesting. I think I would be interested to know what Alice thinks about this. This has been sent back to the trial court, which is the same trial court that heard the case with Judge Newman presiding. And I think one question a lot of people have asked is, will Judge Newman actually hear the evidentiary hearing, or will it go to a different judge?
It's a really good question. Before I get to that, I want to say one more thing about those affidavits. One thing to keep in mind, because I hear a lot of people say they have proof. It's affidavits. In addition to what Brett just said about it not being cross-examined, is that typically with affidavits, attorneys are drafting them. And they're drafted carefully to be able to have the person swear to just those things. There's a lot of things missing in most affidavits, like jumping from one conclusion to another, making connections, right? There's usually, if you have like a story and it's A, B, C, D, E, F, G, an affidavit, just to get over that bare minimum, is probably going to have something like A, and then C, and then maybe G. But a lot of things in between are missing, and that may be because the things in between that are missing are not so clear cut that you can just write it down and have someone swear to it. And so there's a precise way in which to write affidavits to make them fully true. Yet if you had the full story, it may not sound so slam dunk. This is not gaming the system or anything like that. That's just because it's a legal document that you swear to, you have to be very careful. And if there's any nuance, you don't want to get yourself or your witness into a gray area where they swear to the full truth of something when it's not totally true. And there's some more nuance in it, but if you had to explain all of the nuance within the affidavit, it diminishes kind of the slam dunk feel it has, and you don't need all that nuance necessarily to make your point for the motion. So again, this is something that every lawyer does when they draft affidavits, but it's something to keep in mind that even though these people have sworn to their affidavits, and not all of them, if you remember, some of the affidavits were sworn to by the attorney rather than the juror themselves because it was kind of a rushed filing, it felt. And so with all that, there, in and of itself, that filing had missing pieces. It's okay because it has a lower bar to meet, but keep that in mind here. Moving on to that next question, unless, Brett, you had something to say.
Well, I just wanted to say one
drafting.
thing. Joe in the chat has asked whether anybody ever gets charged with perjury. I mean, usually affidavits, it's like Alice was saying, they're written very carefully. So it's not that they're lies. I mean, that's the thing about so much testimony, and it's not, this is why perjury is almost never charged. It's really hard to show someone is out and out lying. It's more, they have their version of events. And that version of events might be completely wrong, but it could be because they're misremembering. It could be because a lot of times the lawyers write the affidavits and kind of convince them that, isn't this really what you think? And then they sign it, and then they get on the stand and they're like, you know what? That's actually not what happened. You know, I mean, these kind of things happen. And that's why affidavits are good. They're absolutely evidence. They're something you should look at. We mention them in a lot of our cases that we talk about on here, but they are much, much less. You give me testimony versus an affidavit, I'm going to go with the testimony every time.
Let me give you an example. So we draft affidavits all the time in conjunction with the witness or the agent because we know the legalese you have to use. You know, kind of the way something has to be framed to fit within the legal framework that you are arguing for, right? So that's why when you say something in an affidavit, when the witness gets on a stand, they may be like, well, I wouldn't say it that way, but the lawyer drafts it that way because that's the legal standard, right? And so one example would be, this has happened in many iterations. This exact thing that I'm telling you is not an example from my life, but something like this happens all the time. Agent, can you swear in this affidavit that the traffic light was green? Ooh, I don't know that it was green. It probably was not green because of all the circumstances around it. Okay, so you can't swear to the fact that the light was green, but can you swear to the fact that it likely was not green? Yeah, I think I can do that. You see how they're like, it's not exactly the same thing, slightly different shades of something, but you throw that agent on a stand and gets cross-examined. It may sound in your affidavit that the light was green, but when he gets on the stand, he's like, okay, I didn't say it was green. I said it was probably not green, which is something different. And then you start splicing and dicing, like, where was your point of view? What makes you so sure it happened at this time? When did the light change that made you put your sirens on and decide to do something? So that's why we say an affidavit may be drafted to sound a certain way, and it's not an outright lie, but it is drafted carefully for a reason.
And this is one reason that, we've talked about before, when you're choosing your witnesses, when you have police officers, you're choosing your witnesses, a lot of times you don't use the affiant because it is just really easy to trip people up based on what they said in their affidavit when they're on the stand. And this comes up a little bit in the Delphi case. Like, you have that affidavit that supports the search warrant. And it's things like, you know, in the affidavit, the guy writes that he was wearing a light blue jacket, but the woman actually says that it was a light jacket. But then there's a picture which makes it look like he's wearing a blue jacket. So you can understand where putting those two pieces of evidence together, he writes light blue jacket. But you can also see how if he's put on the stand and cross-examined, the defense attorney can make him sound like he's not being truthful. And you hear this so much. And this is another thing. People want to call people liars all the time. And you see that in the Delphi case, and we're not to the Delphi case yet, but you see that where people want to say, oh, well, you know, he was lying in that affidavit because he said X, and it really turns out to be kind of X, you know? And we're always very careful when we talk about this because we recognize the way this stuff actually goes down. And it's very easy to just accuse someone of being misleading or lying, when in reality, facts are complicated, and putting all this together in a legal document like an affidavit where you're trying to get the most important things in there without filling them with a bunch of stuff that doesn't matter and cluttering them up can be actually kind of difficult to do. And my question was, will Judge Newman get to hear the hearing?
Oh, great question. Okay, so if you went back and read the original stay papers that laid out the allegations, you may remember that Judge Newman makes his way into some of the factual parts of the allegation. I don't think there were any allegations directed at Judge Newman himself, but I think there was some. He appears in the factual sense at the Moselle visit. There was something about him walking around and maybe seeing things. And of course, there's the dismissal of the egg juror. Right? That there's some allegations there that Ms. Hill misrepresented some things to Judge Newman. He made a finding that ultimately led to the dismissal of one of the jurors. That may or may not be key with the witness tampering part. And I say that because I don't think he necessarily is going to send it to a different judge right away. Because right now it's gone back to the district court. There's a lot to sort through. There are a lot of allegations in that motion. Some of them extremely serious, some of them not. To be honest, I thought it was a little bit clouded with the not serious allegations, but I see why they put it in there, because the not serious allegations absolutely grab people's attention because it's a good story. Everyone knows and remembers the egg lady juror, right? And so to throw in a lot of allegations surrounding whether she was properly dismissed or not is absolutely going to trigger people's memory for when that happened and grab, the media's attention. But whether those are going to be key to whether there was witness tampering or not, I think is another question. I think Judge Newman is going to need to sort through some of this first and determine which parts need to have an evidentiary hearing. If it's going to be all of it, I think he's going to be part of the factual, evidentiary hearing, and he may need to have another judge look at it. But it might be a little bit more nuanced than that. And there may be parts that he can hear, and there may be parts where he has been alleged to be part of the facts, not doing any wrongdoing, just having knowledge of facts that could show there had been wrongdoing. And he may determine that none of that actually goes to witness tampering or rises to the level of needing an evidentiary hearing. So I think it's a little bit early to tell, but ultimately, if there's a hearing on any part where he may be a witness, I don't think he can be overseeing it. What are your thoughts?
Well, I think, like you said, we're kind of early days in this. It's been remanded. I'm kind of surprised there hasn't been further filings yet, but I guess that'll work itself out. I mean, Murdaugh's busy fighting the feds right now anyway, and it's not like it's that much of a rush. He's not getting out of prison anytime soon. I think Newman is going to want to hear this, so I think he is going to not want to send it to another judge. And the initial filing will be with him. The request for recusal will go to him. And you may think that's weird, but that's the way it'll work. And he'll have to make that initial decision. And if he denies that, that's the kind of thing that obviously can be appealed. So this may be something that drags on for a while. I don't think this is going to move very quickly. I think that decision's going to be made. Frankly, might move faster if he just did recuse himself, but I kind of feel like he's not going to do that. Becky Hill, I mean, she doesn't work for him. She's an elected official. Yes, there's some factual things where maybe, but they're relatively minor. You know, like he said something about how he didn't like the fact that Becky Hill was interrogating a juror. Okay, well, he didn't like that. That doesn't really determine anything. The visit to Moselle, I don't know how much goes in there, because one of the things the defense talks about are discussions that happened there that really weren't supposed to be happening. But I think his inclination is going to be to keep it. I do think there will be an evidentiary hearing. I don't see how you don't have one. Now, just because you have an evidentiary hearing does not mean you're going to have a new trial. I actually kind of think at the end of the day, they won't have a new trial. I think they're going to do this. I think the jurors are going to get on the stand. I think most of the jurors are going to say nothing like that happened. I think the jurors who filed the affidavits are not going to be anywhere near as strong on the stand as the affidavits for all the reasons we talked about. And I think at the end of the day, they'll rule no harm, no foul. It obviously will be appealed, but I think that'll be upheld. So that's what I think. I don't actually think we're going to have a new trial in the Murdaugh case, despite everything that's happened.
You've called your prediction. We'll see. I don't think you're completely wrong there. You know, a lot of people are focusing on the very steamy allegations here. And ultimately, at the end of the day, if you guys watched that trial with us earlier this year, which a lot of you did, the weight of the evidence against Murdaugh really was immense. We did not think it was a close call whatsoever. Some of the media coverage may have made it seem like it was a close call, but the weight of the evidence really was incredibly strong against him. And if all these allegations end up fully teased out, which they need to be, bad things can happen that don't affect the ultimate weight of the evidence against him. And that's where we have to, see how it falls. So I hope that is the case, Brett, because what an incredible drain on resources it already is, and it will continue to be if there is a new trial. I fully think that he would be convicted again, but you would have to go through the entire trial again. And a lot of you may already know this. When Murdaugh took the stand, he admitted to a lot of other crimes, a lot of financial crimes, and he has now pled to a lot of federal financial crimes that will keep him in prison for a very long time. So in terms of him serving time, he is not going anywhere. Now, is that a reason not to find justice for the murdered victims? No, not at all. But in reality, where he's going to sit is going to be in prison for a very long time. I
mean, this may just come down to, does he spend the rest of his life in federal prison, or does he spend the rest of his life in state prison? That may be what this comes down to, because he's got these two sentences right now. Right now he's in state prison. If his state conviction gets vacated, he doesn't walk out. The feds have a detainer on him. So the moment his state conviction was vacated, like he is now in their custody, at that point, the state would have to decide, are they going to retry him or not? Presumably they will. So then the feds will let them borrow him for the purpose of trying him. But now that they've got custody over him, even if he's convicted, he'd probably just go back to federal court, not state court. And he would serve his federal sentence. And then when that ended, if he lived to the end of it, at that point, he would be transferred to state prison. So a lot of this may be a little esoteric, like Alice said. It still matters to have justice for the victim. And I think, we want to have a verdict in this case. We don't want this to be a case where we just decide, what difference does it make? He's in prison for forever. But it would be unfortunate for the people of South Carolina to spend all those resources. Do you have anything else you want to say on Murdaugh before we move on to Delphi?
It's funny. Before we started recording, we're like, nothing happened in either Murdaugh or Delphi. There's not going to be much to talk about. And here we go, talking for like half an hour about Murdaugh, which was the smaller of the two in terms of developments. No, I have nothing more to say, but I do think people want to hear about Delphi, because obviously last week we were all gearing up for this hearing on Thursday where we thought there was going to be an evidentiary hearing to investigate who leaked the crime scene photos from the Delphi case. And there were some whispers that it was coming from the defense, and there was kind of a black box for the public. We just knew there was a hearing set. We knew that it was going to be televised. And instead of a hearing about the leak, what happened was that the judge got on the bench and had about a 5-minute colloquy where she advised everyone that there was not going to be hearing at all, because one of the defense counsel Attorney Baldwin, who had actually filed a very interesting memorandum by a lawyer that he had hired just earlier that day, admitting that the leak came from his office, but it wasn't his fault, and why he should not be removed from the case, why he shouldn't be sanctioned, etc., etc., despite that very forceful filing admitting to the leak coming from his office. The judge said there's no hearing today because Attorney Baldwin has moved orally to be removed from the case. And the other attorney was going to file a motion to withdraw from the case in the coming days. And that there was going to be new counsel appointed, and the status conference that had already been set on October 31st was going to continue to take place, but at that point, they would have new counsel and kind of discuss next steps. And of course, with all of these changes, the judge said the trial is going to be moved back. There wasn't a date set at the time, but that was all that happened. Essentially, it was like a bombshell procedural thing. New counsel is going to be appointed. No talk of Odinism, no talk of the crime scene photos. But what does that mean? That the attorneys have been removed. We talked a lot about all that surrounded the removal, but now what? Now what's going to happen? Who's going to be the new counsel? What is their strategy going to be going forward? Biggest question ever, Brett. Are they tied to this 135-page Frank's motion, quote unquote, Frank's motion regarding Odinism?
So there's a lot to unpack there. I think the first thing to say is something Alice pointed out, because, this case generates conspiracy theories like no other. And as soon as this happened, and we knew this was going to happen, as soon as this happened, there were people who were convinced that this was some sort of plot by the prosecution to get these guys removed. And I think it's important to note that Baldwin filed, at one point, he was trying to stay on this case. He hired an attorney, which is so unusual. You never see that happen, and filed something that essentially said, yes, the leak came from our office, but it was someone I trusted who came into my office, and I left some stuff out, and they took advantage of me, and they took a bunch of pictures they shouldn't have taken, and then they leaked it. And this trusted person was not a member of the prosecution team. You can be sure of that. So whatever the truth of what Baldwin said, and there are people who have questioned that, and there are people who've said, based on what was leaked, it's impossible for this to have been a one-time event. It had to be over a period of time. Who knows if that's true, and who knows if we'll ever know that. But what we can say for certain is this leak happened because of the defense, even if just by negligence, and they were removed because of it. The prosecution didn't have anything to do with this.
And something really important to note there is that the defense did not have to make this filing. This was titled memorandum. It was not a response. It was not a motion. It was just a filing. Typically, courts actually won't even allow such a filing because it's just kind of out of nowhere. There's no ask necessarily of the court. The court didn't say anything. There were no public allegations that the leak had come from the defense. So there was absolutely no reason that the defense had to affirmatively say, not our fault. Don't sanction us. That's actually why this filing was so confusing. Because out of the gate, no one's publicly actually said anything about them. The judge hasn't said anything about where the leak came from. And they come running out of the gate saying, it was us, but don't sanction us and don't take us off the case. And we didn't do it on purpose. It truly, if you are following this case in the legal sense on the docket, it jumped out of nowhere. And the judge did not force them to make that confession, essentially, but they did. And they did that. This actually goes back to Murdaugh, because a lot of you asked, why would Murdaugh admit to financial crimes, on the stand? Isn't there a right to not incriminating yourself? Yes. But sometimes in order to get yourself out of even bigger trouble, you have to admit to other things. And that's kind of what this Delphi memorandum filing was. He had to admit, I think, he was trying to avoid something bigger, which was sanctions, maybe a bar complaint, maybe getting a tongue lashing from the judge, a host of things that basically he outlines in the memorandum. He was trying to avoid all those things. And in order to do that, he needed to admit the most basic thing, because I think it was incredibly obvious and he couldn't make that ask judge, don't do all these other terrible things to me without first admitting that very basic confession, which is that the leak came from his office and it wasn't due to anything the prosecution did.
And the leak had been probably about a week before this, maybe a little bit more. So the police had been investigating people. The police had been interviewing people. We know, as we talked about, tragically, one of the people involved in this killed themselves after they spoke to the police. You know, it wasn't as if nobody knew this was coming. Baldwin knew this was coming. He knew that the police had evidence of where this came from. And if this were a normal case, no defense attorney would do what they did. You wouldn't fight to stay on a case like that when something like that happened. I mean, you might fight in court, like in the hearing, you might say the things they said in the filing, but you wouldn't hire a lawyer. You wouldn't do all that. You know, if lawyers get removed from cases all the time, happens all the time. Defense attorneys, we see it all the time. We're going to talk about what happens when a defense attorney gets removed. The number of times that appointed counsel gets removed because they get appointed, they meet with their defendant, the defendant hates them, they fight all the time. Finally, the defendant files something and says, look, I can't stand this guy, give me a new lawyer. And they get removed from the case. And usually they're like, fine, I don't want to be here either, right? This case is a little different. I think these lawyers really wanted to be on this case. I think they were passionate about it, whether because they saw it as a way to fame or because they truly believe Richard Allen was innocent. I can't speak to that. I'm not them. But they really wanted to stay on this case. And Baldwin took that extreme step of hiring an attorney in a case in which he's the lawyer to file something. I mean, it's wild. I mean, that happened is wild.
That's actually a really good point, Brett, because there are situations, and we've seen them a lot, where someone is asking for the defense attorney to be removed. Very rarely the prosecution, but oftentimes the client, so the defendant. And the attorney sometimes does have to respond because maybe there are allegations, you know, the defendant will say something like, my attorney is terrible. He never talks to me. He never calls me. He never, etc. Right? And sometimes the judge will be like, I want to hear from your attorney. The attorney files something himself. He does not hire another attorney to file something on his behalf. And so there are rare situations where the attorney who is being asked to be removed has to respond to some claims because the court orders it or, you know, the situation arises that is called for. But the attorney himself or herself files that filing, not representative for the attorney. I don't think I've ever seen an attorney hire an attorney to file something in the same case matter where the underlying attorney is the representative, because usually those are two separate case matters.
So that leaves Allen without lawyers. This has bothered a lot of you. A lot of you are very concerned about the fact he doesn't have an attorney right now. It doesn't matter. There's nothing going on right now. Like, he needs an attorney for the hearings that come up. You know, when you get arrested, your initial appearance, you need a lawyer. Your arraignment, you need a lawyer. You need a lawyer to prepare for trial. The trial is going to be delayed long enough for them to get lawyers in place. And that just takes some time. It's just going to take some time. This is not an ordinary case. You know, even in our cases, in the most basic case, the guy, you know, we have a hearing. We usually have to step out because usually they're ex parte. We step out. We were brought back in. The judge says, okay, we're getting rid of lawyer X. I'll appoint somebody. Well, it's not like a lawyer just like drops in from the sky right there and all of a sudden they have one. It takes a couple days. And that's even for your most basic case. It's going to take a little while to find lawyers with the capabilities, the staff, the availability, everything you're going to need, the qualifications. Remember, this is a double murder case, death penalty case. Going to have the right people to do this. It's going to take some time, and it is more important to get the right people on the case who know what they're doing than to try and rush this.
And those of you who are worried that Richard Allen doesn't have an attorney right now, it's not like it's a loophole that now the prosecution can rush in and talk to him all they want because he's not represented. In fact, the prosecution will not talk to him at all. If for some reason Richard Allen reaches out to the prosecution, they will likely tell him, we can't talk to you until you have counsel. This happens to us sometimes. Like the defendant will reach out to us directly and be like, hey, prosecutor lady, I just want to talk to you, give you my side of the story. I'm like, I can't. I can't talk to you right now, not without your counsel. They're like, yeah, I fired him. I'm going to get new counsel, but not yet. I just want to talk to you because he sucked as my attorney. And I'm like, great, glad he sucked. Glad you're getting representation. Cannot talk to you until you have counsel. That has happened to me, and I have been called prosecutor lady before, which I personally thought was really great. So that's not happening here. Really, all that's happening is Richard Allen's sitting there where he has been sitting for the last few months, and no prosecution side person is coming to talk to him without an attorney.
And I just want to say that if all the misleading things in this case, the idea that being in a prison is worse than being in a county jail is like I literally had a sentencing recently where there was a filing and it really needed a couple weeks. It's complicated why this is, but it really kind of needed a couple weeks before the filing would be successful. Like at this point, it might be successful. In 2 weeks, it would be successful. And I called the lawyer and I was like, hey, if you want to delay the sentencing for a couple weeks, I am fine with that. Like I won't oppose a continuance so you can like do this thing. And he's like, nah, my guy's ready to get out of county jail. Let's just do it. And he ended up winning the filing, so it worked out for him. But like nobody wants to be in county jail. They hate coming to county jail. When people get moved to county jail for like a resentencing or because they have to testify or something, they're like, get me back to the prison as quickly as possible. So look, maybe the Carroll County Jail or wherever is like the nicest jail in the history of mankind. But this notion that it's like cruel and unusual because he's in a prison with all these murderers. I mean, who do you think's staying at the county jail? The people who are in the county jail are criminals too, right? And he's not actually hanging out with the murderers in the prison. So like, it's never good to be incarcerated anywhere. It's always bad. You don't want it to happen. That's why it's prison. That's why it's a jail. But there's not some like, he's in like, you know, hell right now in this prison. If only he could get to county jail, it'd be so much better. They wanted him in the county jail because it was closer to them. Period. End of story.
I mean, county jail. So think about how things are funded. Taxes. When you have it at the county level, you're just going to have fewer funds. And it's typically for like whoever you get off the streets that you need to hold in jail for a little bit of time. It's not really typically for long sentences. And when you don't have it for long sentences, you typically don't have like all the resources needed to ensure that Richard Allen is safe, for example, that he has amenities, he has mental health access, care access, and all these different things that you need when people are there for a long time. So I've been to county jail before. It is not somewhere I didn't think I was going to get out alive, to be honest.
Yeah. I mean, I don't really want to be in prison either. It really depends. I mean, some county jails are awful. Like I said, I don't know the state of these county jails that he might be going to, but I mean, it can be rough.
A great way to think about it. A lot of counties, they don't have enough funds to make it like where you have a lot of outside time. For example, they don't have a basketball court outside. And guess what? When you don't have a secure place where you can go lift weights and go play basketball and go have like outdoor time, you just don't have it. Because they can't let you out in the front yard to graze. Like, that's not going to happen because it's unsecured. And so when you don't have amenities for your inmates, it just means you don't have them, period. It's not like the alternative, well, we're just going to bus you to the YMCA and play basketball. That's not going to happen because they don't have the resources to do that. And you just can't like release them out to go play basketball. And so that's like one very obvious example that I can think of that a lot of counties don't have the resources to invest in. Like a basketball hoop is the last thing that they can afford because they're trying to make sure that there are enough cameras to cover all of the places that need cameras, for example.
And usually they're super overcrowded. And if you have somebody who's on suicide watch, even worse. Like we talked about this in one of our legal briefs. Actually, we talked about a really terrible case that arose out of a county jail. And they had somebody who was essentially on suicide watch and they didn't really have a place to put them. So they were just in this horrible room with like no water, no toilet, no nothing. I mean, look, maybe factually speaking, someone can prove to me that the county jail is so much better than the prison he's in. But this is just one of those things you see flying around Twitter that like this is the problem is he's an innocent man and he's in prison. It's like, guys, he's going to be held no matter what. He's going to be held behind bars no matter what. That's just the way it works. I'm sorry. When you're charged with double murder, you usually don't get bail. That's life. So I get it. We want to move this along as quickly as possible because if he's guilty, we want him to be found guilty. And if he is innocent, we want him to be acquitted. And we totally get that. But it wasn't the prosecution leaking these photos. It was the defense, and they got removed because of it. So here we are. Let's say that tomorrow they get new attorneys. What are they bound to do? This has been a question. Are they bound to do what the last defense attorneys did? The answer is pretty simple. The last defense attorneys weren't bound to do anything. Like, if Baldwin had decided, never mind, this Odin stuff is ridiculous. And this Frank's motion, somebody on Facebook said it's barely even a hot dog. We're just going to get rid of it, right? They could have done that, and it wouldn't have meant anything. They could have pulled those motions. They could have never mentioned Odinism again. Wouldn't have mattered at all. What's going to happen now is you have these new lawyers coming in, still at very early stages in this case. They're essentially going to start over. These filings will remain pending. At some point, they'll essentially decide, are we going to sort of reaffirm those filings, or are we going to withdraw them and make our own? I would think, no matter what, even if they agree with the Odinism thing, I bet they withdraw all those filings and do their own and sort of like put their own stamp on it, their own approach to it. Even if they want a Frank's motion, they'll write their own Frank's motion. They'll do things like cite Indiana law. It'll be amazing. And I think that will be their approach. I think they will sort of, they'll have to go through all the discovery. Everything starts over. I mean, it's as if we're starting from square one. Really. And that's not always true. Like, there are cases where somebody fires their lawyer right before trial and the judge tells the new lawyer, we're going to trial in 2 weeks. You better be ready. Not this kind of case, though. That's not going to happen in this kind of case. And like I said, we're not that far along. So I think you can expect there's not going to be a trial till at best end of next year, but maybe 2025 is what we're looking at now. The wheels of justice grind slow, guys. They always grind slow. And this is particularly true here because whenever you have something like this happens, it slows things down even more. But it takes a long time to try these cases. And frankly, I think that's the way you want it to be, because when remember the Darlie Routier case? They moved that one right along. And what does everybody say now? How could they prepare for a murder trial in 3 months or whatever it was, right? And I think that's, yeah. So these new lawyers are going to come in, new opportunities, new filings, new arguments. They may stick to Odinism. They may have like a take on it that's less conspiratorial, but maybe has hints of it. Who knows? But they will have an opportunity to do their own thing.
And a major reason I think they're going to not fully adopt the Frank's motion or the Odinism filing is because they have the benefit of seeing how it played out in the media, right? Yes, it made a splash. Everyone read it, but it did not have the effect that perhaps defense wanted it to, which was to say that everyone would be hunting for Odinists wherever they are, and that people were fully bought into this. If you hang out on some social media threads, maybe some people now are fully convinced that Odinist did it and that Richard Allen had nothing to do with it. But it did not have that full effect that I think the defense wanted it to have. It got people talking about the case, but newsflash, people were already talking about this case, and it did not make the defense look very good, especially with the way this all played out, with at least some allegations that perhaps the defense wanted these crime scene photos released to bolster their filing. I have no idea if that's the case or not, but that's certainly in the Twitter sphere. And because they've seen the circus that has been around it, if I were them to be taken seriously, I would absolutely pull everything back and start from square one. You want that as well because you've seen the way the judge has reacted to the previous defense counsel, and you want to distance yourself as far as possible from all the wrongdoings of the attorneys that are withdrawing from the case. And the other thing is, this is why, even before new counsel was appointed, the judge said something that was very obvious to anyone in the legal world. The trial date's not going to stay. Another thing that the defense is likely going to do when there's new counsel is to hire their own investigators and investigate the case. So investigating has probably already been done. Sounds like it was all down the Odinism trail. And even again, like Brett said, they go down some version of that story. They're going to want their own investigators who they trust, who they work well with, and be part of those interviews and those judgment calls of what to investigate next.
And really, I mean, in some ways, this is great for the defense because, or if you're a new defense attorney, because number one, you may never mention Odinism, but it's out there. So you might get some jurors you never talk about it. Prosecution never talks about it. But you might have some jurors who in the back of their mind are thinking, I think it was Odinist. And you never even have to bring it up because your, former people laid the groundwork for it. But you don't have to tarnish your own reputation or, there are going to be jurors who, if you mention Odinism, are going to say you're crazy, right? Like, I don't think you're going to get an acquittal, a straight acquittal if you're arguing Odinism. Maybe you get a hung jury, but I don't think you get a straight acquittal. But if you can sort of have Odinism in the back of people's minds, but never mention it, that's not bad, right? So they have that. And the other thing is, they can really appear so much more level-headed and competent than these last two jokers. I mean, they can come in and file a real Franks motion that like actually lays out the law and makes better arguments and does them in a more cohesive way. They could do the Odinism thing in a less sort of sensationalist way. Like, they benefit greatly. Sometimes you're having to fill big shoes and it's bad. Sometimes the shoes are not that big. They're too small to even fit, so you just throw them away. And I think that's where we're at in this case.
And the best kind of, we always say there's good cop, bad cop. You need a straight man for your jokes or whatever. They have all of that, but they never have to interact with them because they've been removed from the case. There's such a low bar for them to seem like the level-headed, hardworking attorneys based on a lot of the tactics that were employed by former counsel. And they get to kind of be compared to an extreme version of kind of what you don't want to do when you're a defense counsel without ever having to say explicitly, look, I'm better. So you're right. Like, I mean, this is fantastic for Richard Allen's case. This is like this is really good for him. I'm not going to say it's the best thing for him, but it is this does not prejudice him at all, despite a lot of people saying, oh, this was all a conspiracy to make sure he gets convicted or whatnot. If anything, I think this is very good for Richard Allen.
This will make it much easier for me to be unbiased in analyzing this case too, because now that they're gone, I'll tell you, I despised these lawyers. Like, I could not stand them. Everything they did was like an affront to the legal profession. So I am so glad they're gone. I think Richard Allen is far better off having new attorneys, and I hope they're serious people who take this seriously. There are, as we have discussed ad nauseum, and as has been discussed ad nauseum on other channels, this case, we think it's strong, but you can attack it. There are ways to attack this case, and there are ways to sort of show reasonable doubt in this case. I'm sorry, I don't think Odinism was ever going to be it. I think that was a joke. But I think these new lawyers are going to come in, and I am hopeful that they are level-headed people who will actually grapple with the evidence and really give us like a real trial where we actually figure out whether or not Richard Allen's guilty beyond a reasonable doubt. That is my hope. I'm very hopeful now, and I look forward to this case moving forward.
I mean, for example, I think that they should, in terms of what the defense should do, attack the search warrant. I don't think it would be granted, but there are better reasons than Odinism to attack the search warrant, right? We've already talked about this before. Now we know the manner in which the girls were murdered, which is different than what I think originally we thought, which had to do with an unspent casing of a bullet, right? Which is, now that whole thing, there should be a lot of expert testimony on that. That is really interesting to grapple with, whether you can actually tell whether a bullet that cycled through a gun but wasn't actually shot, you can tell what gun it came from. That is like going to be factually, expert-wise, legally very interesting to talk about, which was never really even brought up by these defense counsel. And I would say that's the first thing that people who know about guns or law enforcement investigations kind of latch on, like, wait a second. That's what happened with that gun? And they're saying they can tell which gun it came from? That's kind of the first question that jumps to people's mind. And they were like, Odinism.
Right. I mean, look, and I get it. I mean, Odinism captured a lot of people, and I know there are people who are listening who absolutely believe it was Odinist. I can anticipate your comments, your YouTube comments already. But I'm sorry, guys. It wasn't Odinism. Okay?
Oh, sorry.
I was just going to say, even if the people who have been identified as Odinists did it, they did it for reasons unrelated to some sort of pagan religion. Like, it's not a sacrifice, okay? It's not a sacrifice.
One thing these defense counsel will have to grapple with, that they can't just say, you know what, that was the artistic creativity of past counsel, we do not adopt these arguments, would be the jailhouse call confessions by Richard Allen.
Yeah.
You can't get rid of that. Facts are facts. And that's a fact in that he said those things. It's recorded on the jailhouse calls, and they will have to grapple with that. They can't say, with the Franks motion that we're throwing out, we're also going to throw out those confessions. They will have to grapple with that, and that's going to be difficult. So we'll see what they do with that. We'll see what they do. It's more than once. It's going to come up in multiple settings. Whether their tactic, for example, is to come in and start working with prosecution to work out a plea deal and stop filing all these motions, especially when they can tell from the filings from the prosecution that the prosecution was incredibly frustrated with defense counsel. You can read it in the responses, and you can understand why. They were having to respond to these really voluminous filings and having to retread old ground by citing the law, something very basic, and they didn't feel like they were actually having a legal fight that was worth having. They were just playing whack-a-mole with the defense counsel. So the new defense counsel also has that benefit of coming in and potentially being like, hey, I don't know what happened between you guys, and I can understand why you're frustrated with them. Look, I'm here to do the job. I've looked at the case. I've looked at the evidence. I've heard his confessions. Let's actually talk about a resolution that's best for the victims' families and for my client here. Maybe the previous counsel couldn't talk to each other. Maybe there was just too many butting heads that they couldn't reach a resolution. I don't know. We're not part of those conversations, but that might be another tactic that this new defense counsel will come in with.
And that's a great point. This new defense team may come in and want to make a deal. And that may be the best thing for Richard Allen. And one thing that's always hard for lawyers, particularly defense attorneys, when you're a lawyer, there will always be a case that presents some sort of interesting aspect that you, brilliant lawyer that you are, really want to grapple with. And you want to file something where you argue some sort of like out of the blue novel theory and you're going to change the law, right? The problem is, at some point you have to ask yourself, how likely is that to succeed versus something else I might do that maybe I don't get the total victory that I want, but I get the best outcome. I've had cases where, we've had the vast majority of the laws against us, and then there's like one judge who's ruled in our favor. And you can write a brief arguing that judge got it right, but you know what's going to happen. The other side's going to come back and say, the reason they cited this case is because it's the only judge who's ever said that. We got 100 judges who said the other thing. And no matter how powerful and persuasive and brilliant your argument, most likely the court's going to go the other way. Same thing here. Maybe the defense attorneys, they got so wrapped up into this Odinist thing, and maybe they truly believed it, and they thought, we are going to uncover this massive conspiracy that just is, the police are riven with Odinists, and they're Odinists everywhere, and these guys have patches in the jail, and that means they're part of the cult, and they intimidate, and they believed that, and they really got wrapped up in it. Most likely that was not going to succeed. Most likely that was going to fail. But in pursuing that, their client's life is on the line. Like if they roll those dice and it doesn't come up, lucky 7 for him on that first roll, he's getting the death penalty. The new lawyers who come in may say, look, we got these confessions. We got all these sightings. We got his own statements. We can fight about the bullet, but are we going to win? Usually that stuff comes in. Let's make a deal.
And the other thing is, some of you may be thinking, well, if Richard Allen wanted to take a plea deal, that would have already worked out. Here's the thing. Like we said, the prosecution is never talking directly to the defendant, and they never should be, especially if they're represented. Your counsel has a lot to do, especially in a complex murder case, to do with client management. And I don't know what the previous counsel's relationship with Richard Allen was, but I have seen dramatic change within a defendant's kind of entire realistic view of the case when they've changed counsel. Some counsel just can't get through to a particular client to get them to understand the severity of the consequences that they're facing and the strength of the case against them. And they may have fueled it. Maybe they wanted a trial. I don't know. There's nothing wrong with going to trial, even if it's a strong case against your client, if that's what your client wants. But a good attorney knows when you really need to turn it up to a 10 in terms of convincing your client, look, I'm going to tell it to you straight. This all can happen exactly like this. The decision's up to you, but I need you to understand clearly what your decision entails. And some attorneys are better at conveying that than others. Ultimately, it's the client's decision, but maybe there is an opportunity for some realistic discussion with Richard Allen. If he had been the one to shun all sorts of negotiations for a plea deal, maybe new counsel can shed some light on what could happen if he continues down that path. Well, we've hit an hour, and this is only round one of of 2 rounds tonight. So we could keep going. We could really do many legal briefs on this. And I envision many legal briefs on this because there will be additional developments in these cases. This is just the beginning, both in the Murdaugh case and in the Delphi case. This is the first procedural step of more to come. And so I would say stay tuned and don't grab onto any headlines that tell you definitively this has happened in the case. Nothing has really happened in the case in Delphi in terms of with respect to the defendant or in Murdaugh's case, except for a first procedural step to then additional steps that need to be taken. Brett, is there anything else you'd like to add?
I got nothing else tonight. We'll be talking about these cases a lot more as there are more developments, but keep your questions coming. We're always happy to answer them.
Absolutely. Thank you guys for asking these questions. We hope we've been able to demystify some of this for you. And if you have additional questions, please feel free to write us at prosecutorspod@gmail.com. On all the social medias, we are at prosecutorspod on X, Twitter, Facebook, Instagram, and we love hearing from you guys. So thank you guys. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. And he kept he was cutting things with it, like a woman would hold something in her mouth. And I was just like, dude, someone is gonna lose a limb and it's not gonna be okay. And kids were running up to the whip and he was like, almost got you there, Sonny. And I was like, all I'm saying is this was an awesome rodeo that would not be allowed in 49 states.
I feel like Alice has never been to just a small town fair
No.
slash rodeo.
I grew up in Texas.
Well, they must have been a lot fancier in Texas because this sounds pretty standard to me.